All rise. The Court of Appeal in and for the Fifth District of the State of Florida is now in session. The Honorable Harvey L. Jay, Chief Judge, presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to all, and thank you for being here on time. We've had some calendar changes, and we appreciate your patience with those. As the Marshal just told you, I'm Harvey Jay. I have the honor and privilege of being Chief Judge of the 5th District. Today in Jacksonville, we have an all Jacksonville panel. So something we don't see every day. I'm here with Judge Kilbane to my right and Judge McIver to my left. A couple of quick things I know we've got experienced counsel, but I want to remind you of, and I would be remiss if I didn't recognize my law clerk who is here with us, Stephanie Higgins from Orlando, her son Emmett, and her husband Dan. So great to have you guys. I probably would have heard about that later had I not recognized them in the beginning. But a few reminders before we get started with the oral arguments today. Obviously, we don't grant oral argument in every case. I know the experienced practitioners know that. So given that dynamic, it would be greatly appreciated if you would listen carefully to our questions. That doesn't mean we're right in what we ask, but being responsive to those would certainly be appreciated. We will do our best not to interrupt you and your advocacy, but in the midst of that advocacy, we may need to ask questions. We apologize in advance for that, but those questions are a large part of why you're here today, as I know you probably know. The second thing, this is a court of law, and please be mindful of that. If you have electronic devices, if you would be kind enough to make sure those are silenced. As I'm fond of saying, you don't want to be that person that alerts everyone that you have an electronic device that is not silenced. So those are all the lead-ins to this process. Mr. Nordby, on behalf of the appellant, you can come forward, and just so we're clear on the record, this is Sanford Airport Authority versus Orlando Sanford International, case number 2025-2306. And Mr. Nordby, on behalf of the appellant, would you like to reserve any time?
Yes, Chief Judge Jay, I'd like to reserve 5 minutes for rebuttal, please.
All right. When you're ready, please proceed.
Thank you very much. Good morning. May it please the court, Chief Judge, judges of the panel, Daniel Nordby, Ricky Polston, and Brett Renton on behalf of the Sanford Airport Authority. This appeal is about whether a government contractor performing delegated public functions at a public airport can avoid Florida's public records laws because the records request came from the agency itself rather than from a private citizen. The answer to that question is no, and the judgment below should be reversed for at least 3 reasons. First, under Chapter 119, the records, the definition of agency includes private contractors such as Orlando Sanford International, OSI, the appellee here, and the authority is entitled to request public records from it.
Before we hear you on that, Mr. Nordby, we are here on the amended complaint, correct?
We are, Your Honor.
And that is the operative complaint for our evaluation.
That's correct.
And as I know you know, and you have read about in the answer brief, there are a lot of attachments to that amended complaint, correct?
That's true.
As I understand the law, and I'm not suggesting necessarily there is a contradiction between the attachments and the complaint, but if there is, the attachments control. Is that your understanding of the law as well?
So Judge Jay, my understanding is if there's an attachment to the complaint or an exhibit that negates an allegation in the complaint, then the attachment or exhibit would control. If there are competing inferences or a dispute about the facts between an exhibit and an allegation in the complaint, that's not the sort of dispute that's appropriately resolved at the pleading stage.
And that's a good word, negates, and thank you for that. I think that may have been the Supreme Court's word in Fladell, the butterfly ballot case. So if an exhibit does negate the pleading allegations, the exhibit would control, and then we would evaluate the complaint based on the exhibit, if there's a negation.
I'd agree with that. If the two are irreconcilable, if it negates it, then the exhibit will control over an allegation. If there's a dispute, factual dispute as to whether it does, for example, or inferences to be drawn, that's something that the trial judge should not resolve at the pleading stage. Trial judge should instead just accept the well-pleaded allegations of the complaint.
One of the attachments to the amended complaint is the agreement between the agency and the contractor. Does that agreement negate the allegations of the complaint?
As a general matter, what I would say is no. I'd be glad to answer any more specific questions, but no, I don't believe that the agreement negates any allegations made in the amended complaint.
There are three components, I think, relevant to our analysis today in that agreement. One of those is the dispute resolution provision of that agreement. Did your client plead that it met the dispute resolution components of the agreement?
Yes, Your Honor. At page 272 of the record, which is paragraph 40 of the amended complaint, we alleged that the parties had mediated their disputes and that mediation had reached impasse. I understand in the answer brief, OSI has attempted to contest that, at least as the Sunshine Law claim. If OSI, I would submit, if OSI has a dispute on that issue, they could deny that allegation.
Would it matter anyways? I'm curious if it would matter anyways. I understand that the Public Records Act in the contractor provision says the public agency shall enforce the contract provisions in accordance with the contract. So you ask for records, they say no, your enforcement mechanism is through the contract. But can the agency and the contractor put into their contract something that would delay or obfuscate the public's rights to those records? You may very well have put into your contract that it requires mediation, but this gets a little bit skewed because it's the agency asking. If this was a member of the public asking, would anyone be so bold as to say that we could put up obstacles to the public being able to get that?
Yeah, I think the answer to your question is clearly no. And we've cited cases for the principle that agencies cannot, by contract, retract rights that rightly belong to the public. The NCAA case, for example, is one example of a case we cited standing for that principle. My answer to Judge Jay's question was that even if that was required, we've alleged that we have complied with the dispute resolution process. If the defendant wishes to assert as an affirmative defense a failure to comply with conditions precedent or to deny that allegation in their answer, they can do so. We never got to that stage because the trial judge resolved this on a motion to dismiss and dismissed it with prejudice out of the gate.
Go ahead, Judge McIver.
So for the sake of argument, let's say that we agree on the threshold question, that the term person in the Constitution and in the Act is broad enough to encompass the agency. At least for counts 1 and 2, you were dismissed for res judicata. Can we look back to that original dismissal and say that was wrong because of this threshold question, or are we limited to looking at the order on appeal, which said you were dismissed because we already answered this question with prejudice?
Judge McIver, I think you can look back at the underlying basis there. The sequencing of this was a little odd. We had a pending motion for reconsideration of the original dismissal at the time that we had to amend in accordance with that dismissal order. So to ensure that those arguments were preserved, we realleged the arguments that had been dismissed with prejudice to ensure that there was no preservation issue here. I think the order dismissing the amended complaint, as you said, referred back to the reason it was dismissed before. So the underlying reason for the dismissal, I think, is well before you as well.
Back to the agreement, Mr. Norby. I asked you about dispute resolution, which I believe is sub 14. I just pulled up sub 12, provision of information and so everyone understands, that's the provision of information from the contractor back to the agency. Why would that not negate counts 1 and 2? Why would point 12, provision of information, not negate counts 1 and 2 of the amended complaint?
So Judge Jay, section 12.1 of the contract does not displace chapter 119, the public records obligation, or section 18.27 of the contract, which is a separate provision specifically addressing public records, because those provisions of the contract do different things. Section 12.1 is a contractual inspection provision that's tied to compliance, to monitoring compliance with the contractual obligations. But as we pointed out in our briefs, section 12.1 itself includes a clause that says that it does not apply to the extent that information is required to be made available to the authority by any legal requirement. So it itself, section 12.1, contains an exception acknowledging that there may be other legal requirements that would require production of information. And that's at page 375 of the record. Now,
and I see that, Mr. Norby, and just so we're talking about the same paragraph, this looks like page 61 of the agreement, notwithstanding the foregoing. Is that what you're referencing?
it is, yes.
It says the contractor shall be under no obligation to make available to the authority any information about the costs incurred by the contractor in exercising its rights or performing its obligations under this agreement, except to the extent that such information is required to be available, made available to the authority by any legal requirement. So you would say that legal requirement would be the Public Records Act?
I think two answers. First, absolutely the Public Records Act. Legal requirement is a defined term in the agreement. It's defined at section 1.49 of the agreement to include any statute. Certainly that includes the public records statutes. Another legal requirement that imposes an obligation here is section 18.27 of the contract, which specifically addresses the contractor's public records obligations.
Can I just ask the adverse of that question really quick? If that exclusion that you point out didn't exist, can the agency and the contractor by contract say something is not a public record, which by statute is a public record?
Absolutely not. By contract, a party cannot eliminate public records obligations. In this case, section 12.1 provides an additional means over and above the public record obligations of OSI for my client, the Sanford Airport Authority, to gain certain information that it needs for monitoring compliance with the contract. So the parties can require information to be provided that might not be in the form of a fixed public record. The Public Records Act, for example, does not require the production of a public record. So parties can contract for additional.
So a floor, not a ceiling?
That's correct.
Well, I want to make sure I understand that. You would agree a constitutional right, so-called explicit constitutional right, can be waived by your client by contract?
Yes, as a general principle.
It happens every day. I mean,
the party can waive a constitutional right. That's right. My argument is a little different. My argument is that we have not done so here because of the terms of the contract and the explicit recognition that other legal requirements may also require the production of information.
And I don't want to speak for Judge McIver. It seems to this judge, Judge Jay, that his example is a little different than a waiver by the agency of its own constitutional right. I fully admit, I think we all do. If the public is asking for something, the agency and the contractor can't say you don't have any right to it because we've agreed you don't have any right to it because the principally affected party has not agreed to that. But in this case, it looks like the principally affected party, i.e. the agency, has agreed to the waiver. At least that's the argument by the contractor. And if in fact that's happened, it can be waived. You'd agree to that.
So I'd agree that it is possible for a party to waive its own constitutional rights. I would disagree that they've done so here for the reasons I stated. The exception to 12.1 specifically recognizes that other sources of law may require OSI to provide information, public record information, for example, to the airport authority. And our argument is that's what they've done. That's what they've done here. They've not waived that right.
And but as you said, that the legal requirement may be over and above the sunshine, but you're essentially alleging that the legal requirement is the sunshine because it's derived from the statute. So if OSI is, it's a little bit limited, right? They're not a public agency. So they're attached to the public agency. So if those documents that have been requested don't fall under the sunshine, let's say, then what legal requirement is tethering you to be able to get those documents? Because it seems like maybe an attempt to use the sunshine where maybe it may or may not apply.
So OSI is a public agency. It's defined as as an agency rather under Chapter 119 to the extent it's performing delegated duties on behalf of the airport authority. And that's the definition in 119.011 sub 2. The definition of agency for purposes of Chapter 119 includes, quote, any private agency, partnership, corporation, or business entity acting on behalf of any public agency. So notwithstanding the fact that OSI is a private corporation, there's no dispute about that. For purposes of the public records law, they are by definition an agency when they're performing their delegated duties. Now, it may be that they have records unrelated to the performance of their duties, records that were not created or made in connection with their duties here. Those would not be public records. But the analysis as to whether a particular record is or is not a public record, is or is not exempt from the public records law, is something that the Public Records Act addresses. Those can be reviewed in camera by the trial judge to determine whether some exemption or exception applies. Now, we've given an example.
Am I correct that that definition also does not turn on whether you are viewing this through the agency lens or the contractor lens? A public record is a public record.
It is. It absolutely is. And the OSI has made a point in their brief of saying that there may be attorney-client communications in some of these public records. That may well be true, but it's also a very well-established principle of Florida public records law that there's a very limited attorney-client privilege when it comes to public records. And there's a process for asserting an exemption if it's a specific work product relating to pending or imminent litigation. Other than that, public agencies all over the state have found that their communications with their attorneys are public records and might have to be disclosed if they don't fall within the confines of that narrow exception. So, as I said, our principal argument depends on the statutory text of Chapter 119.
The statutory text also references more specifically them as a contractor, correct? Under, what is it, 119.0701, right?
It does.
Okay, and then it sort of curtails specifically down discussing in 2B the requirements for a contractor, which is defined and does reference the agency definition that you said. Does that change anything about their obligation as opposed to a general state agency, public agency?
It does. In fact, Section 119.0701 imposes additional obligations on them as a contractor. We don't disagree with the general thrust of their argument that Section 119.0701 was enacted to streamline the process for obtaining public records from government contractors. We don't want random citizens showing up at contractors' offices and demanding records. So this streamlines and funnels the process for third parties to request records from the agency, which then requests records from the contractor. Our argument is that by doing so, by providing a streamlined process, by imposing obligations on the contractor, Section 119.0701 does not silently repeal their general obligation under the Florida Constitution and Chapter 119 to produce public records upon request, including the type of request that we have here. We noted that one of our requests dealt with records that we'd received as to the structural integrity of a parking garage, that it appeared from the limited records we did receive that it had been heavily edited to suggest that repairs might not be needed in contrast to what a consultant had recommended. That was concerning to my client. So we asked for additional records, and as soon as we did that, they shut down. They said, we're not giving you anything at all. We're not going to give you any records here, and they denied any obligation to produce records whatsoever. I see that I'm into my rebuttal time, but I want to be sure I've answered the panel's questions on the first stand.
Thank you, Mr.
Thank you very
Norby.
much.
Morning, may it please the court. My name is Daniel Rogers from the law firm of Shikardi and Bacon, and I represent the appellee Orlando Sanford International, Inc. Your Honors, this appeal is not about public access. No member of the public has made this request. That is critically important. What is it about? It's about a governmental agency that's
What i-
trying to
What is a public agency?
The public agency here is the Sanford Airport Authority.
What's the word agency mean?
The word agency is defined in chapter 119 to include things like the authority and then anyone.
In a
who
very
acting
broad
on
general
behalf-
sense, what does the word agency mean?
Oh, outside of the context of the statute, just generally, what is it?
Yeah,
mean, Your
what's
Honor?
an agent?
Well, it is somebody who's acting on behalf of somebody else that has, the principal has control over their actions.
Who is a public agency acting on behalf of?
Who, the public agency here is acting according with their charter that's.
Is it right there in the name? The public agency is acting on behalf of the public?
But, I see what Your Honor is saying. So then.
So has there been a public request?
Your Honor, there's been a request by the public agency. There has not been a request by a member of the public. And that
There's been a
distinction
request
is-
by the public's agent?
I don't know that that's necessarily true, Your Honor, because we're talking about in connection with a specific statute, 119.071, and it defines a public agency differently than the public and differently than a contractor. And so Your Honor is creating a distinction that is actually different than what the legislature created. You're trying to import definitions that are not actually in the statute.
Did the legislature make those terms mutually exclusive?
They did not make those terms mutually exclusive, but what we've cited in the case law is that when you have statutes that both on their face could apply, you look at the more specific and recent statute because that is what the legislature intended for that specific purpose. You don't look at the older, more general statute. That is what the Florida Supreme Court and this court has repeatedly said.
If they're in tension, if they're not in tension, if those terms are not mutually exclusive and they're not in tension, then it seems to me you could look at both.
Well, you need to apply one or the other. You can't apply both at the same time.
That's what mutually exclusive means.
Okay, well, then they are mutually exclusive as applied in this context, Your Honor, right? Just the same way the cost statutes, right? There's a cost statute under.
So they're
Public
mutual,
Records
they're
Act.
mutually exclusive and the public agency is not a person under the Constitution who has rights to access to public records.
Your Honor, let me take a step back here, right? When the Florida legislature amended the Florida Public Records Act in 2013, they said the public shall have the right to request documents from a contractor as if it was requesting it from a public agency, right? A person, the public, has absolutely that right. Then what did they do in 2016?
Were
They
they
said-
limiting a constitutional right or were they clarifying a constitutional right? The Constitution says every person has access to those public records. So the threshold keystone question here is, does public agency fall within the definition of every person?
But, right, Your Honor, the public agency involves in the definition of a person if you're looking in the context of 119.07, right? 119.07 does not apply here. Okay, as I was trying to explain, in 2016, the Florida legislature specifically amended that statute to say the public, i.e. the people that they are supposedly agents for, are not allowed to make those requests directly to the contractor. So accepting that interpretation means that the public agency has more rights to request public records than a member of the public does. That is absurd. That's not what the legislature intended.
Does the agency have constitutional rights?
The agency has constitutional rights that it is allowed to waive by entering into contracts where it waives those rights.
Well, and Mr. Rogers, that was my next question. So they have constitutional rights and they have the right, the privilege of waiving those constitutional rights.
Yes, Your Honor.
And where is that waiver here? If we're looking for a waiver in the complaint or the attachments to the complaint, I know that's part of the argument in your answer brief. Where is that? Where is the waiver?
Absolutely. And I think Your Honor hit it on the head with section 12.1, right? Section 12.1 is the controlling provision, and it has specific procedures on which of my client's records the SAA, the authority, is allowed to inspect. And it includes specific waivers.
Given-
They say we're not allowed to. inspect
Given my-
certain things.
Given my earlier hypothetical, can you address that? Let's set aside the fact that the agency is making the request for a second and say, let's say they were acting in the pass-through capacity that you say they are cabined to. If they were acting in that capacity, would 12.1 be able to limit the public's right to what they could and could not get?
So your question said limit the public's right of what they can get, right?
Yes.
Those are two different things, Your Honor. There's the public's right to access, which is unfettered, right? And the agreement and the everything here.
If I made a request through Sanford Airport Authority for public records, would my request be cabined by the provisions that you've contracted with
No.
12.1?
No.
Okay.
Absolutely not, Your Honor. We are absolutely not taking the position that the public is in any way waived their rights. And any suggestion to the contrary is completely wrong, right? So let's talk about, right? Your Honor talked about how the agency and the contractor cannot put up a public obstacle to the public's right of access. We absolutely agree with that, Honor. That's not this case because there's no member of the public that has sought access that has been denied. Instead, what we have is a situation where
Under 1827,
Hmm?
under 1827 in your contract, does the agency have to tell you anything about the public records request other than what records they need?
No, under 18.27, they need to relay it, the public records custodian, the custodian of public records from the public agency.
Says, "I need
will
these
relay that
records."
request.
Okay. They don't have to tell you who made the request?
I don't know if exactly that's in the contract, whether they have to identify the name of the specific person. I know in practice they do that. When they have done that, we know that from the attachments to the complaint.
Is your contention that it's implicitly within the Public Records Act?
Yes, because of the distinction in 119.0701 between the public, a public agency, and a contract, which are all different. They cannot be the same, right? That is the issue, right? And Your Honor also talked about how the agency and the contractor cannot contract that something is not a public record. We've not done that. There's nothing in this contract where we said that this is a public record or that's not a public record. That is not in the contract. That's an issue that hasn't even been debated in this case, right? The public is not bound by any of that. We can waive the rights between the parties, OSI and the authority. They can enter into contracts about what records they're allowed to look at and what records they're not allowed to look at. Now, the SAA relies upon.
Can they? Hold on, whoa. Let's revisit that statement real quick. You can enter through contract what records they're allowed to look at and what records you're not allowed to look at. So if the Public Records Act says something is a public record, you can by contract say that they're not allowed to look at that?
But in a contractual setting, yes, if the public has not made a public records request. Yes, in a contractual setting, that's what the parties agreed to in this contract, right? And then.
So you are saying, let's assume for a second that you and Sanford Airport Authority were not adverse. You could essentially contract your way out of your public records obligations is what you're telling me.
Not from a member of the public, no. Member of the public always has their rights.
So we keep coming back to this then, that the key threshold issue is whether or not they would fall both under the definition of public agency and also under the definition of person. Did the legislature expressly say that they don't fall under the definition of a person? Did they draw that exclusion expressly in the statute?
No, Your Honor, if you look at the definition of a person, they don't even talk about it.
So my understanding.
That's not even in there. The authority, word authority is not even in that definition.
My understanding, and take your opportunity to correct me if I'm wrong, is that your argument is that that distinction is implied by the intent of them making the amendment in 2016.
It's not, I mean, it's clear if you look at the actual, what they redlined.
Is it
out of the
express?
text.
Clear's a word we kind of get to decide on. Is it express?
There was a statute that says the public shall be allowed to get it from the contractor just as if they were a public agency. That the legislature struck that out, right? Said, no, you are not allowed to do that anymore. right? What you have to do is you have to make the request to the public agency, and the public agency then needs to pass through that request if they don't have it, right? That's what the contract says. So it doesn't in any way say that anybody in the public or a public agency
So-
has that right.
So then the answer to my question of was it express in the statute is no.
Well, there's nothing,
Did the legislature,
can't
did the
offer you any more
legislature
than
say it in the
what's happening.
text? Did the legislature say it in the text? Or did
They-
they imply it through their action?
They clearly implied it through their actions. If we look exactly at what they X'd out of the text and what they added to the text, I don't think there's any other reasonable conclusion here. Right? There's no fair reading of the statute. And what the SAA relies upon is that they're not bound by the limitations that they agreed to and their waiver of their rights to access these records in 12.1 because it has an exception for any quote legal requirement, right? That is the classic case of the exception swallowing the rule, right? If they could go ahead and request any of these documents through a public records request because that is a legal requirement, then that completely abolishes and nullifies all the agreed limitations and their waiver of all of their rights to see these documents,
Public agencies allowed to sue generally for public records issues?
right? There,
Not necessarily just their contractor, but can a public agency file a lawsuit? Do they have a right to access to the courts
yes,
as is provided to every person in the state of Florida?
yes, sure.
So when it comes to being able to sue, I'm just looking at a very interesting parallel between the constitutional provisions that give you right to public access to records and rights to access to the courts. They both provide those rights to every person. So in the public records context, you're saying that a public agency is no longer a person. I'm wondering how they can even sue in the first place.
Well, that we look to the case law that says that the public agency can waive their right to go to court. There's cases that have held if they agree in a contract to arbitration or dispute resolution, they are bound by that. And therefore they've waived their right of access to the courts. So these are waivable rights. What I think we need to come back to, Judge McIver, is what Judge Kilbane focused on, which is the statute that is applicable in this instance, 119.0701. Any reference to 119.07 is completely wrong for this case because it would allow, if that is the one that applied and not the contractor specific provisions, that would mean that the entire system would be a nullity, right? The whole reason why they created that would be a nullity if they could just bypass that whole procedure and go with the original general statute. And so I think
Where in that particular statute is the pass-through obligation?
right? When it talks about how the requirement is that the public needs to make the request first to the public agency.
Does it say that?
Yes. Absolutely. Right? And then once the public agency gets it, it needs to determine if it has those records. And if it doesn't have those records and it believes the contractor has them, then the custodian of public records for the public agency passes it through to the contractor for the contractor to see, do you have those public records to be able to respond to a member of the public? This is the procedure that the legislature enacted because they wanted to make sure that contractors like my client are not hit with direct public records requests from the public or public agencies or anybody else. They have contractual rights because they are contractors. And so they have a contract which includes 18.27, which mandates that they have the right, they have the obligation to retain documents that are public records and respond to requests for public records when they are relayed from the custodian of public records of the public.
I'm reading a provision that requires the contractor to comply with public records laws, specifically two, upon request from the public agency's custodian of public records, provide the public agency with a copy of the requested records or allow the records to be inspected. I don't see where that is cabined by a condition precedent that they have to receive a request.
So in other words, Your Honor, you're saying the statute gives the public agency more rights than the public? I don't quite understand that, right? And if you're just talking about it's the public agency that's doing that, they create that in the
My
contract.
simple question was, where in the statute does it say that this restriction that you're putting forward, where is that in the statute?
It's when.
Tell me the words.
But Your Honor sees the language. Obviously, there is not the exact words in the statute that Your Honor is looking for. But if Your Honor looks at how the statute was enacted and its history and its text and how it's applied in this context, that is what it does. Now, Your Honor's hypothetical.
You're
where
telling me you want me to
it's-
rely on the supposed intent of the statute rather than the text of the statute?
No, we absolutely rely on the text of the statute. Your Honor,
Okay,
Right?
so
And it
where in the
is-
text does it say that they have a condition precedent to have a request from the public before they can make that public records request?
As I said, Your Honor, that is not expressly in the statute.
Thank you.
But that is the context of exactly what this statute is about, right? That is exactly what this was enacted for. And I think that Your Honor, if you're looking for those exact words in there, the legislature needs to spell all that out in express terms every time, then that would destroy all the canons of construction and mean we don't look at any of those canons of construction. And that's obviously not what the law requires.
Did OSI receive a request from the agency's custodian of public records here?
No. No, they did not. They received a request, a public records request under the general provisions of the Public Records Act, specifically cites 119.07, and it's from the president and CEO, not the records custodian or custodian of public records. The attachments to the complaint establish that that is Ms. Gilmore. She is the records custodian, public records for the agency, and she is not the one who made that request, the president and CEO.
And the statutory text and the agreement say records custodian.
Correct, Your Honor. Yes, because the custodian of public records for the public agency is the one that needs to make that request, right? Because the way that it is set up is that the custodian of public records is the one that would get the public records request from the public. So they would be the ones that would search to see if they were there.
Is the Public
and
Records
pass it
Act
along.
strictly or liberally construed?
I didn't hear your question, Your Honor.
Is the Public Records Act strictly or liberally construed?
It is strictly construed.
The Public Records Act is strictly construed? I'm
Well,
pretty
like-
sure the
like
text of the
broad-
Public
you said
Records Act.
Broadly, yeah, it has broad, it should be broadly construed to effectuate the intents purposes. Yeah, that's it.
Okay, so would it be a very strict reading of the statute if we said that you didn't have to answer a public records request because it came from a CEO rather than someone with the title of public records custodian? Or that the CEO could not designate themselves as a de facto public records custodian? It seems to me that's a pretty strict reading.
So I just want to hearken, Your Honor, back to the discussion we were having a couple of minutes ago, where we had to talk about the express language of the statute, and that's what we're relying upon. And Your Honor now says we should not look at the express language of the statute and we should look at something different. I don't know how to deal with that hypothetical, Your
You're
Honor.
not saying anything, I'm asking you.
But we have a situation where statute says the request needs to be made by the custodian of public records. That statute needs to be applied by its express terms, and in this case, it was not complied with
What
based
is-
on the attachments to the.
What is the custodian of public records under the version of the act that you're operating under? I realize that there's been an amendment later that says that agencies have to actually designate someone to be the titled custodian of public records, but I don't believe that was in the statute at the time that we're discussing, correct?
It was, but the reply brief was wrong. The reply brief said the contract was signed in 2009. It was actually signed it operated in 2017 and signed after the statute went into effect in 2016. But the parties just mistakenly did not include that provision in the contract, but it was actually a legal requirement at that time, right? But at the end of the day, what we know from the attachments to the complaint which control is that Ms. Gilmore is the records custodian, and the statute requires the records custodian to make that request. That's the plain language of the statute, and that's what we're relying upon, Your Honor.
So just on that point, so that really what the statute is talking about is what the contract must contain when a public agency engages with a contractor. Is that correct?
Absolutely, because the legislature was viewing this from the perspective that the contractor is bound by the contract. The contractor should not be the one that's bound by the Public Records Act as a public agency, so include it in their contract to make sure they're contractually bound.
But is the contractor, as defined here, is the contractor's obligation under the Sunshine Law limited by what's in the contract? Or is there a further obligation once they engage in a contract with a public agency?
But they have a contractual obligation to be able, as specified in the statute and as specified in their contract, to maintain those public records, not destroy them, make sure the exemptions are maintained. Those are their obligations specified in 119.071. Those are their obligations in section 18.27, and those are what they comply with. Right? They don't have any greater obligations than what's in their contract and what's in the contractor specific provisions of the statute. The general provisions didn't apply. That's why we had all these amendments in the 2010s to get away from exactly what they're trying to do here. But yet they believe that they have the authority to basically come back in, ignore, the Public Records Act. So we would ask that your honors affirm these claims fail as a matter of law. They have not done what is required to request public records, pursuant to the contract and pursuant to the contractor specific provisions of the statute. To accept their theory is to invert the Public Records Act on its head, to erase 119.071's contractor framework and nullify bargained for contractual provisions that they were allowed to enter and waive their rights. Do not allow them to basically ignore all of their obligations.
I see that you're just about out of time, but if maybe we could go just a little bit over.
Certainly, we can go over and I'll give Mr. Nordby,
I'm
whatever
curious
that time is. Thank you,
about the
Judge
mootness
McIver.
argument on issue number 3. If you are still in possession of public records and you do still have a continuing public records obligation, under the idea that their declaratory judgment act request was now moot, what are your obligations? Are you still in a subordinate agency that is subject to the pass-through provisions, or are you now an independent agency?
We are required to comply with the contractual provisions that are.
Well, you're no longer a contractor with them. That was the whole point of the mootness provision, that they can't seek a DEC action against you at this point because you're no longer the contractual entity. But if you still have a continuing public records obligation, what is your status as an entity in possession of public records?
Exactly.
Would the public make those requests to you directly in your view, or would they have to make that request through Sanford Airport Authority still?
They have to make that request to the Sanford Airport Authority, because that is the only way that you're allowed to request public records is through the public agency and not directly of the contract.
So then that would seem to entirely undermine your mootness position then.
Your Honor, I would love to be able to spend a couple of minutes talking about mootness, but the declaratory judgment action there's no bona fide dispute for that if the court agrees with us on the other claims that you should not have done this. So we don't even need to reach the mootness issue.
Well, we do if I ask the question.
What?
We do if I ask the question.
Okay, yeah, and so happy to discuss that, Your Honor, right? So we have a situation here where what you're talking about is different aspects of the declaratory judgment claim, right? And in this particular case, what is the declaration that they are seeking? They are seeking a declaration that we need to comply with the third public records request. That issue is moot, and that issue has nothing to do with the hypothetical that you're talking about, right? Where you're seeking a declaration as to whether a member of the public, whether or not OSI needs to be able to respond at some future point in time to a request from a member of the public that's passed through the public agency to them,
Okay.
right? That is a different claim. The claim that they've actually pled is moot. If they get some future claim like that, right, that may require some sort of declaratory action. But as we know from the May versus Holly case, that type of hypothetical situation in the future is inappropriate for a declaratory judgment action. The court doesn't have jurisdiction to address that hypothetical at this time.
Thank you, Mr. Rogers. And for the benefit of the rebuttal time, if you would add 4 minutes to the time.
Thank you.
If you need it, Mr. Nordby, we'll see.
Chief Judge, I want to make sure I have enough time to answer all of your questions. I will attempt not to use any more than is necessary to do so. I do have just a few brief points in rebuttal. One of them, picking up on something that Judge McIver asked. I don't think there's any question as a general principle in Florida that public agencies can request public records from other agencies. They've done so without any controversy in a number of cases. We cited in our brief a Hernando County case that Judge Jay, I believe you were on that panel for. The case didn't address that principle. It just sort of was accepted. Of course, a public agency can request records. We've cited a City of Pembroke Pines case as well that involved one government agency requesting public records of another agency. So as a general proposition, I don't think there's any question that a public agency can request public records from another agency. What we've heard is what I think is a somewhat remarkable assertion that apparently anyone in the world can ask for records about the structural integrity of the parking garage at the Sanford Airport, other than the Sanford Airport, that they've somehow contracted away their right to get those records. I think that's wrong as a matter of contract law for the reasons I stated earlier. 12.1 includes an exception that would recognize they may have legal requirements to provide information other than that information specifically identified in 12.1. Maybe the argument is that the Sanford Airport Authority should have asked itself first for the public records, determined that it didn't have them, and then passed that request along to the Orlando Sanford International. I'm no opponent of formalism, but I think that stretches it to a large degree. Our reading of section 119.07 and section 119.0701 harmonizes those two provisions. They do different but complementary things in providing access to public records to effectuate the right under the Florida Constitution. Their reading creates unnecessary conflict between those two provisions of law. And as between a reading that harmonizes two statutes and one that brings them into conflict, the one that harmonizes those is the one that should be adopted.
And thank you for all that, Mr. Norby. I did have a question I didn't have an opportunity to ask you during your main argument, so I'm going to ask it now.
Please.
And back to that word, negate. I'm going to read to you, this is from a 6th DCA case, but I think it's a fair statement of the law, and then you'll see why I'm reading it. This is Polk State College. It's a 2024 6th DCA case, but here's the quote. When an exhibit contradicts the allegations, the exhibit controls, and instead of contradicts, I think maybe we could insert in, as you did, that great word, negates the allegations, the exhibit controls. The variance is fatal, and the complaint is subject to dismissal for failure to state a cause of action. For that quote, the 6th is citing our decision in Appel, the 2010 5th DCA case. All that said, appended to this complaint is the order dismissing the initial complaint and all the reasons behind the order dismissing the initial complaint. How is that not fatal to your arguments in the amended complaint? I don't know how we can reconcile the language of the order with what you have pleaded, but help me understand.
Just to be sure I can understand your question. So your question is the amended complaint includes as an exhibit the order dismissing the original complaint?
Yes, sir. And it is incorporated into every count.
Okay. Certainly the amended complaint doesn't cite the order dismissing the original complaint or as an affirmative assertion that it was correct in doing so. If that was an exhibit, and I apologize, I don't recall if it was. It may have been as part of the, I certainly don't doubt you is what I'm saying. If it included as an exhibit the original order, I'm certain it was for the purpose of the procedural history of how we got to the amended complaint, rather than as an assertion that Judge Brzezinski was correct in dismissing our original complaint. So I don't think that falls within the general principle that you stated that I agree with from the 6th and from this court, that you should take the exhibits and the allegations and the exhibits control over. I don't think that would apply to a prior court order dismissing the original complaint. On a similar topic, though, I did want to address what was an allegation in OSI's answer brief that there was, that there's an inconsistency between the allegations as to the records custodian and the exhibits as to the records custodian. We did assert at paragraph 83 of our amended complaint, which is at page 281 of the record, that OSI refused to produce records requested by the custodian of public records. So that was our well-pleaded allegation in our complaint. Now, they've asserted that because that letter that was attached was from the president and CEO, that, to use the word, negates the allegation that that person was also a or the records custodian. The contract here never identifies who any records custodian is, and it never says that that Ms. March was not a record custodian or acting on behalf of a records custodian here. I think my friend on the other side inadvertently misstated something in the record. He stated that Ms. Gilmore in one of the documents was identified as the records custodian. What I assume he's referring to is at page 460 of the record, which refers to someone named Christina Gilmore as a records manager. It doesn't say records custodian, it says records manager. So there is nothing in any of the exhibits here that negates the idea that Ms. March was acting as a records custodian, and our allegation, which should be accepted as true, states that that the records custodian asked for these records.
And did Ms. Martz represent in that letter, I don't have it in front of me, that she was on behalf of the authority or anything of that she was associated with the authority?
It was on the authority's letterhead, and I think it even identified her title on the side of it. So it was not a question about whether it was a request from the authority. Now, there was a separate issue that we have not yet discussed, where OSI has taken issue of whether Mr. Renton's letter was on behalf of the authority or whether it was, I suppose, on his own behalf as a curious citizen or on behalf of some unnamed client of our law firm. The trial judge drew the inference that because Mr. Renton's letter did not explicitly say on behalf of the Sanford Airport Authority, there's no way to know who he was acting on behalf of. I don't think it's proper to resolve those sort of inferences at the pleading stage. I think even if you were to resolve inferences, this letter was sent 5 days after the order dismissing the complaint because the trial judge found we hadn't adequately alleged the Sunshine Law claim. I think the far more reasonable inference on correspondence from Mr. Renton to Mr. Rogers is that it was on behalf of the airport authority in the very dispute here under. Unless there are further questions, we would ask you to reverse consistent with the arguments of our brief and remand for further proceedings. Thank you.
Thank you. Well presented as expected on both sides. So why don't we give them a moment to clear?